We formed a quorum and it's also the scheduled time. Please invite the administration to join us. We have a government's response to the follow-up issues raised at the Bills Committee meeting on the 12th of January 2018 in paper CB2 834-17-18-01. We set out our concerns and the administration has prepared a response by way of paper bracket 02. The government has already given us a reply, and is there anything to add to the paper? Not really, Chairman, but I'd just like to say that in annexes A, B, and C, we have got the complaints handling systems of the two universities. And members may want to ask questions on the annexes, and I have nothing more to add. Thank you. I said at the last meeting that we are going to arrange a meeting, an informal meeting between the administration and also members who are concerned about the cosmetics sector. And the meeting has been held, and the concerns have been addressed, and I think the issues have been sorted out. If there are further concerns, now actually the bill is not directly relevant to the beauty sector. And if there are still concerns, I don't mind arranging another informal meeting for the administration and members concerned about the sector. And then at the Bills Committee, rather we focus on the bill itself. So I think we have had a number of meetings, and many of the issues have been rehearsed time and again. So I think we have to be more efficient. I open the floor to members for questions. Each will have 4 minutes. Dr. Pierre Chen and Dr. Fernando Chen. Dr. Pierre Chen. Thank you, Chairman. I'd like to ask a follow-up question on the definition of premises. And that's clause 8 of the bill. I ask this on behalf of doctors. In many clinics and jointly operated clinics, they encounter this problem. Under 8A or B, we have the definition of premises, places that are in close proximity. How do we understand the term in close proximity? For instance, rooms A, 2A, 2B, and 3, are they in close proximity? Given the geographical situation in Hong Kong, Mongkok and Yau Ma Tei are rather close to, so some doctors are concerned. As to whether they have to close down the clinics they are operating because of this. Well, this is about the bill itself. Is clause 8 of the bill, right? If the administration can, please reply to Dr. Chen's question. If not, we can wait till the clause-by-clause stage. Can we wait till we have the clause-by-clause stage? The problem is I don't know whether I'll be around when we come to clause 8. Dr. Chiu. Thank you, Dr. Chen, for your question. So you are talking about clinics and ambulatory day procedures centers. Now we're talking about hospitals. Maybe there is another block just across the street and of the same hospital, and they are considered as the same hospital. And clauses 8A and B have to be read in conjunction. They will have to explain to us the operation of the clinic. Well, some hospitals may have another clinic in an entirely different district, and they will have to be addressed in the future. And as for clinics, I do understand the scenario referred to by Dr. Chen. They may belong to different units, but they have to explain to us. Now, for some clinics, medical consultation is done at a certain location, and then other procedures are done at a unit next to it. So the two will form a distinct whole, and then that can be dealt with under one license. No. Let me put it the other way around. I'm talking about doctors in solo practice or with less than 5 doctors. Now, for instance, my ward office is very close to Dr. Fernando Jones, and we share clerks and also accountants. Is that possible? Now, if they split the 2 units into 2 different licenses, can that comply with the law? Well, if within the same unit there are 2 practices, that can be allowed. For exempted clinics, they have to show us the exact boundary of its practice. Thank you. Dr. Fernando Zhang. I still have some queries, rather basic one, fundamental ones, when it comes to exclusion for the 2 universities. The administration's paper said that to cater for the ever-evolving landscape of healthcare services, such as the emerging markets of ambulatory day procedure centers and clinics. So we have to regulate these new practices, new modes of practices, but we have to safeguard public health and safety. We have to ensure that people operating in these ambulatory day procedure centers and clinics are subject to reasonable regulation to safeguard the personal safety and health of the public. These are most important. The 2 universities have got 14 such facilities. Now they belong to the 2 universities, and they're set up for the main purpose of teaching and research. But they also provide medical consultation, diagnosis, and treatment. The fact that we have to safeguard the health and safety of patients do not change. We cannot say that protection of lives falls secondary to the purpose of teaching and research. I don't see any logic here. So you have given us a number of reasons in your paper. I still fail to see the logic. In particular, you have the view the 2 universities has got sufficient checks and balances. They have good governance structures. So what they for sure will do more than is required in this bill. So it would not make any, it's effortless for the universities to comply with the bill, and there is no harm in regulating them as well. I don't see the logic as to why the facilities run by the 2 universities should be exempted. Mr. Fong. Thank you, Chairman, and thank you, Dr. Zhang, for your concern. Yes, we do understand that the safety and health of the public are of paramount concern. There is no question about that. But for facilities operated by the 2 universities, we have had detailed discussions with the universities. We have gone through their literature, and I'm of the view that they have put in place a very comprehensive mechanism to deal with everything. For instance, they have a complaint handling system, and then the contact persons are listed out in the annex. They have got a very comprehensive and robust system, and the purpose of the bill is to regulate services provided by private healthcare facilities, PHFs. And the primary purpose of these facilities run by universities are for teaching and research, and this is not directly relevant to the purpose of our regulation, so we've decided to give them exemption. It's not whether we worry that they can do it. Rather, we believe there is no need to duplicate the regulatory efforts. We tried to explain this to members at the last meeting, but let me reiterate. Come today, when they have facilities that are not mainly for teaching and research, we will require them to apply for a license.
Now, Chair, when Mr. Fong talked about the two systems, now we are setting up the legislation, and there is another system applicable to the universities. And the two universities basically formulate their own regulations. But we're talking about legislating for the private healthcare facilities now. And the two universities, medical centers, are private healthcare facilities. It's just that the purpose is for teaching and research, not for commercial gains, that's all. But the safety and care for patients would remain. Well, as mentioned, you're basically repeating yourself. If you want to further extend, perhaps you should ask the question in the next round. The next members, please. Chair, in terms of point 42 and 43 concerning the exclusions and the exemptions and the requirements for the exemptions. Now, concerning the two universities, the 4 sites and the exemptions for the 14 sites, I would like to know whether in point 43 there will be an explicit mention of the two universities, or whether it will be, as we see tabled, it is in the form of a letter, the exclusion or the exemption. I would like to know what exactly will the exemption be given. What is the form of the exemption? Would it be in a letter, please? At present, we want to, in the part of interpretations, amend 2 and 3 therein. As for the exemption letters, that will be applicable to small healthcare facilities, so that would be a different treatment. Professor Zheng. Well, Chair, I think Mr. Fong had still not been able to explain the fundamental principle, because care for the patient and safety for the patient is first and foremost, and teaching and research comes secondary to that. I do not believe that the bill should be exempted from the two universities because it is a teaching and research institution or medical center. But still, the purpose of the bill is to protect the basic rights of the patients, their safety and their care. So I still do not hear a good reasoning from Mr. Fong as to why the universities should be exempted. Now, the government in drafting the bill had not thought of exempting the two universities, and we come into CSA. Perhaps the government will come up with their own amendment in this regard. I mean, they have come up with this amendment to exempt the two universities. I would like to know what had transpired in the midst. Why had the government come up with this new proposed exemption for the two universities? Is that they all of a sudden remember that they have forgotten to do so? What had transpired, please? Chair, in fact, we have discussed in detail in the previous meeting concerning these 14 sites, whether they have referred to HA practices, and in the last meeting by Black and White, I have already explained the situation, and they do refer to the HA practice, and the bill would not actually include HA clinics as well. So definitely, the safety and care of the patients been dealt with satisfactorily by the existing practice. And in the deposition, the CU and the Hong Kong U representatives have spoken that they would want to see exemption for their medical centers. And we have therefore gone back and looked at it further and therefore come up with this proposal. That is the background. Follow-up question, Chair. Mr. Fong mentioned that it is because the two universities said that they will follow the HA practice. No, not true. The administration had given us all the papers concerning the entire system. I got it, Chair. Now, for a private healthcare facility, if they say, oh, we follow the practice to the letter, let's say, what the two universities have, we will also honor. You cannot exclude that possibility. Some of the private healthcare facilities are large in their scale. And if they say, yes, we follow the HA practice, you exempt the two universities, but do not exempt me. What do you say to that? Well, apart from that, there is another leg to the consideration, and that is a very fundamental difference, and that is these two, the Hong Kong U and the CUHK medical centers are for research and teaching purpose. Well, Chair, what's the relevance of that? I mean, there can still be treatment which can go foul in these research and teaching medical centers, jeopardizing the health and safety of patients. What's the relevance? Chair, further to that, yes, the university centers, apart from being teaching and research facilities, they also comply with the HA practice. So they are safe as well as being teaching facilities. Xiu Kafei. Now, first of all, on the medical director, in the paper it says that a medical doctor can fill that role. And in the past few meetings, we have discussed this point. And in the profession, I know there are some 200 to 300 doctors which are in the practice of beauty and services. And in the future, maybe there will be 600 to 700 such beauty services clinics. And this is very different from the 3,000 or 4,000 such clinics. As for medical doctors, I'm sure they're all looking at this bill. And if the medical doctors are diverted to other services, then the people of Hong Kong are concerned whether they will have to wait a long time at the emergency facilities or the emergency services at the hospitals because the doctors are diverted to other services such as beauty clinics. Mr. Chair, in drafting the bill, we also have to look at the actual implementation. In a clinic, how many doctors will have to be stationed there? We see that medical doctors at the most, will have 2 clinics, morning, afternoon, in 2 different clinics respectively, or Mondays, Wednesdays, Fridays in one, and then the other days in another. So for the medical director role, we can go back and see whether the person can be stationed in different clinics. And, well, Chair, Mr. Fong is talking about the situation where a medical doctor would have 2 clinics. In the morning, he'll go to one, and in the afternoon to another. Now, but I'm really talking about injection of Botox, etc., the beauty, so-called, or cosmetics surgery clinics. I mean, there are not that many patients or clients, and if you can make it more lenient for them, then the medical doctors can practice in more than 2. They can practice in multiple clinics. And these medical doctors, I'm sure the FEHD are not concerned about how many Botox patients there are, but what you're concerned about is whether the clinic or the shop is safe, because you fear that there may be hygiene concerns or medical procedures concerns, and that is why you want to appoint a medical director to be working in these shops or clinics. Yes, Mr. Fong confirms that. Now, but it doesn't say in the bill as to what these medical directors need to do. I mean, if they are there to make the clinic safe, what are some of the procedures that they have to carry out in order to comply with your FEHD requirements? Yes, there will be a practice note issued concerning these clinics, day clinics, as well as hospitals. Yes, and the draft of this practice note has been uploaded. We as LegCo members have not seen it. We're LegCo members, we've not seen it. Well, in fact, we have done some consultation with the profession, and it is in draft form uploaded onto the website. You can look at it as LegCo members, and you can ask questions afterwards, and we can have amendments, and we will further consult the profession. Well, they've only talked to the profession, they've only talked to the medical doctors. We've had so many meetings already on this bill. We've not been shown the draft. Well, we have a lot of further meetings on this bill, and we can further discuss this. Chair, in fact, we have a lot of practice notes. There are different practice notes for different clinics, and we have been consulting the profession, and we have been amending and revising the practice notes. And there was one which is for day clinics, and perhaps we can provide the practice notes, all the practice notes, to the members, please. Chair, I've heard him said a few times that he's been consulting the profession. Now, the beauty service clinics are also included in this bill. I've not heard from the beauty clinics that they've been consulted. The stakeholders, the boss of these beauty clinics are also medical doctors. And have they been consulted? No, they have not been consulted. This sector, it's that simple. Thank you, Chair. As I have mentioned just now, this is in draft form and it's uploaded on the website. We continue to consult the profession, including the beauty services clinics. Yes, we will be meeting with them. It is going to take place. So if anyone, including this sector, have anything to tell us about the draft practice note, we will be listening. Now, On 55 in the bill, paragraph 55, there is preliminary mention, there is the legal the responsibilities of the medical director is contained in paragraph 55 of the bill. Now, when we're talking about short-handed, we're really talking about the public hospitals. There are a lot of private practitioners in Hong Kong. Over 50% of the doctors are in private practice, so there is no lack of doctors there. And I heard an argument just now saying that there will be a diversion to beauty services clinics. Now, we will be seeing a lot of graduates from the medical schools, and I do not think that they will be short-handed. Now, I mean, please, I have my own profession. I am an internal medicine doctor, and I will not be going into beauty practice. It is not that with more beauty clinics that we will change our practice. Now, I'm looking at the complaints handling system for the two universities. In the response from the government, we see that they trust in the structure for complaints handling of the two universities, and therefore there is this exemption. Now, I've been in the practice or following this for over 10 years or close to 20 years, and finally I find an answer. Because of this letter, we're able to pursue this.
Well, one of the procedures in the complaint handling system of both universities is to set up a committee to investigate. So I'd like to know how is the membership of these committees decided? And even for some incidents, they said that investigation has started, but we don't know who is involved in the committee and also the progress. For the HA, they will make open such procedures. But all right, now comes the test for the two universities. I'd like to know what are their procedures, because the process is very different from that of the HA. For how the committees are set up by universities on individual incidents, we really don't have any information on that, because it really depends on the circumstances of the case. But if Dr. Chen is interested, please give me some specific examples, and I can ask the universities for details. Now, say for example, every time HA sets up a committee of inquiry, well, they will find someone who is not in that specialty, and they may even find a layman to sit on the board. And every time they have this practice, and HA has got a few panelists, a few sets of panelists, and I like to know how it is done in the two universities. Well, I am satisfied that you are satisfied with the arrangement, but then I have some uncertainty, so I'd like to check with you. Well, to play safe, I think I will find some examples from the two universities and how they appoint members to such committees. Well, when we refer to specific cases, you will say that you don't comment on individual cases. When I put a general question to you, you talked about, you asked for specific cases. All right, it's okay for you to check with the two universities. I will await your response. It really depends on the specific case concerned, because they have to know what is the nature of the complaint and also the complainant. Yes, I can give you information. Now, if you ask me for the HA, we will not ask the hospital involved to investigate a case involving that hospital. For instance, I don't know whether a committee set up by Hong Kong U will appoint someone from CU. So you want to understand more about the mechanism? Yes, I will let you know after the meeting. Mr. Xiu Kafei, second round. So Dr. Chen said that no all doctors would go into the cosmetics industry. Yes, that may be the case for some doctors, but I've seen doctors who started as a GP and gradually went into different specialties. I think this is happening in Hong Kong. Doctors will go into different specialties. And I know of a doctor, an eye doctor, who has gone into the beauty industry. So it does happen. So I like to know, do you know, for doctors registered to practice in the cosmetic industry, do you know how many of them have a specialist in this sector? We don't have any. No. Well, in fact, for doctors I know working in the cosmetics industry, they are not a specialty in this discipline. They are from different specialties. This is to argue about Dr. Chen's point. He said that doctors would not go into this industry. No, this is not the case. When we had babies born of parents who were not permanent residents in Hong Kong, many doctors went into the O&G specialty because of that. So I think there will be both public and private sectors attracted to this industry, and this will pressurize or this will strain our resources, doctor resources. If I'm wrong, correct me. And for the duty of the superintendent is in clause 55 of the bill. All right. That's all we can see regarding the responsibilities of the chief medical executive. So only a few provisions, and it's too general and not specific enough. So Dr. Chiu, please show us the code of practice, because doctors are not the only stakeholders in this bill. I don't care what doctors are doing because I'm a layman. I dare not argue with doctors. For regulation of doctors, you discuss with Dr. Chen because I am a layman. But when it comes to the beauty industry, well, this is what this bill is about. You talk about discussing with stakeholders for a long time. Well, I've never been approached. No one has ever discussed with the beauty industry. So you don't respect us at all. You only discuss with doctors, whereas this bill is not here to regulate doctors. The bill is here because of the DR incident. How come we are never involved? All right, at the end of the day, we don't have enough doctors. People cannot fulfill the requirements in the bill, and what should we do? Not all legislators are doctors. Not everyone in Hong Kong is a doctor. Chairman, you talked about the use of local anesthetic topical cream for anesthesia. One doctor can only be the chief medical executive of two PHFS. This will not do because we don't have enough doctors to go around in Hong Kong. All right, Mr. Fong. One doctor to oversee two clinics. We don't have enough doctors. You'll be draining all the doctors from our public and private sectors to this. And the prices will go up. It's just a common sense. for beauty or ladies or men who care for their look are willing to pay more. So the day will come when we've reached the threshold when we do not have enough such operations in Hong Kong. People will go to Shenzhen or Taiwan, and then we have no other industries in Hong Kong. So should everyone join the financial services industry? Be assured, Mr. Shiu, we have not really finalized the code. We have just published it for consultation. We're saying that the code applies to beauty parlors already, and when it is revised, we've discussed with the clinics, and when the code of practice applies to the facilities under this bill, we will then start the consultation process. Mr. Shiu, rest assured, we are in no way disrespectful of non-doctors who will be covered by this bill, and then we will start to discuss with the industry. And as for the Chief Medical Officer Executive, well, we do understand that there is a real concern, and we understand the operation of the beauty industry. So we may consider increasing the number of clinics that can be overseen by one chief medical executive. We will consider this seriously. Should I go on, or should I have to wait for another round? Mr. Fong is very conscientious. He has discussed with me many times. I appreciate his efforts. You said that the code of practice has been a subject of consultation of the industry. I beg to differ because we've never been approached. And you talk about putting this code of practice onto your website. Now, I am discussing this bill here. Once this bill is passed, then who will speak up for them? Because we are discussing this bill, you should show us the code. We'll talk about the responsibilities of the chief medical executive. Do we agree that the code of practice is very relevant in the scrutiny of this bill? All right, you're going to show us the bill afterwards. Please teach us. We are laymen. We are ignorant when it comes to professional matters. But our petitioners are very serious. They would like to understand whether they can do it, whether they can continue to operate, or should they close down their business. So my focus is the CME having to can only oversee 2 clinics, and this is impossible. Well, as Mr. Fong said, they will consider your views very seriously, and he will even consider whether chief medical executive can only oversee 2 clinics. I think he has already answered your question. He will reconsider that issue. Because the head said that usually a doctor will go to one clinic in the morning and then to another in the afternoon. But that is not the mode of operation of doctors in the beauty industry. I will come again in the second round. Dr. Chen, I thank the administration for responding to the suggestion by the Hong Kong College of Pathologists. Well, the DR incident is one of the reason why we have this bill. Now, the laboratory is claimed that the laboratory tested for bacteria, and the finding was bacteria-free when it was not really the case. And this is about the standards of the laboratories, and therefore we have this proposal from the Hong Kong College of Pathologists. They have spotted loophole, and I'd like to ask the administration how they're going to plug the loophole. I'm afraid this is not relevant to the bill. No, we are asking whether there can be premises-based regulation. we are discussing exemption, and here there is a college of pathologists, and they would like to introduce premises-based regulation. Well, every bill has a focus. This bill is about dentists and medical practitioners carrying out medical or treatment procedures in facilities. And for other healthcare professionals, including nurses and other allied professionals, are not covered in this bill. And this bill is really that thick. The scope is so wide, and we have to be focused. That's the purpose of our bill, and therefore we have not addressed the needs of other allied professionals, health professionals. For the Hong Kong, for the medical laboratory technologists, they have their own MLT board. And now, for advanced medical treatments, we will see whether we will legislate to cater for new developments. We will do so gradually, but I hope Dr. Chan understand what's the focus of this bill. Well, noted. But doctors are subject to regulation. Now, when a doctor is convicted in court, will not come out and put up a banner and raise funds to support him.
Let's say if I were a medical doctor and I am engaged in medical procedures in a big medical group's clinic, and I know nothing about what's going on in the other parts of this big clinic. And for instance, there are medical personnel engaged in testing, and that would be not related to other practices. Now, this is something that I'm concerned about because the bill doesn't include this. Well, because we do see there are very serious practices, grave practices, which are not included under the ambit of this bill. As medical doctors, we're very happy to be governed by this new legislation. Well, if there are, let's say, pathologists in the clinic, then this will become a medical premise and it will come under the ambit of this bill. So I'm not saying that we are dealing with all possible situations, but this particular situation is definitely dealt with by this bill. Now we have Shu Ka-fai again, and after this round we will ask a legal advisor to tell us his opinions concerning the points he raised with the government earlier. And then we'll go clause by clause. After that, the administration will continue to consult the medical sector on the practice note, including the beauty services practitioners. Shu Ka-fai. Chair, concerning the two entrances for premises, for the beauty service centers, one room would probably be for laser, Botox injection, and another would be for massage, etc. But if you want to make these two rooms separate entrance facilities, and I think it would be, one, not very feasible for certain flats, and secondly, it would look very strange. Well, we will go back and consider how we can actually be realistic in the implementation, and secondly, for beauty centers, how we can avoid being overly disruptive to the operation of a beauty center. And we will be talking to the industry as well. Chair, we're talking about the entrances and the administration will talk to us and me again afterwards. But this is not in this bill, right? This is a separate discussion. Is this part of our SSA then? Well, actually, in the past few meetings, we have had detailed discussions concerning entrances. And there was one possibility raised, whether through one entrance, after entering from that entrance, there can be a separation of rooms for different operations. We've discussed that as well. So for the beauty services profession, perhaps Mr. Shao and other members who are concerned about this sector, and also the sector itself, perhaps can discuss this further outside of this meeting. Chair, if the administration has certain proposals after discussions with the sector and it is acceptable to them, we may come back up for certain amendments. Perhaps we should talk to the beauty services sector first before we decide on the next step. Yes, as the government or administration talks to the beauty services sector, after that there can be CSA, and or alternatively the members themselves can raise certain proposals, and that's up to you. Chair, I want to talk about the 0.5 to 0.7%. This substance is exempted. Now, I've talked to some of the pharmacists. 0.5 to 0.7%. How high is this, and what does it mean, this kind of concentration? Well, and they told me anything under 1 is for ulcers, this kind of anesthetics. 2 to 3% is for hemorrhoids, and anything higher is for eyebrow tattoo, etc. But if this is exemption only at 0.5% to 0.7%, is for treating buccal cavity ulcers only. So that is to say, this is still a hanging issue. We've discussed this before, and we've had closed-door meetings even, but it's still not resolved. Well, this is not related to the bill strictly, but on the other hand, this is something that requires a medical doctor to provide a prescription. And if it is set at 0.5, 0.7%, as the exemption threshold for this kind of anesthetics, then I think you would only be making the beauty service clinics fall foul of your requirement. I mean, 0.5 to 0.7 is just for mouth ulcers. I don't know what it is good for, really. It's not good for beauty services. Would you want to consider raising that threshold? This is not within the ambit of the bill. But, Chair, indeed, this is not within the ambit of the bill, but under Cap 138 concerning pharmaceuticals control. But on this concern of the beauty service sector, we will bring this opinion back to the statutory body for the administration and control of pharmaceuticals. Yes, indeed, this bill will not be able to resolve that issue raised by Mr. Xu. Further, I urge for this tattooing business using laser even. In fact, this is very professional work. And if there is sufficient training, for the beauty service sector, and the beauty service sector raises its own standard and becomes more professional, I think this will also help safeguard public safety. And I hope the administration would also take this into consideration in your future formulation of bills and practice notes. Do keep this opinion in mind as well. Now, our legal advisor, please. Anything to supplement, please, further to the questions you've raised to the administration? There are a few concepts in the bill on which I've written to the administration for clarification. First of all, the meaning of medical procedure and also the relation between medical procedure, quote unquote, and its relevance to medical treatment and other terms. And in the paper, CB 226291718, the administration had come back with responses. I have no further points to make. All right, let us go clause by clause now, if there are no further questions or points. Mr. Lee, you'll bring us through the bill? Yes. First of all, the long title of the bill. And this is the Private Healthcare Facilities Bill. And the bill itself, the focus is to bring in a new private healthcare facilities regulatory structure to take the place of Cap 165 and Cap 343. There is Part 1, which consists of Clause 1 to 9, and it consists of the short title and commencement date. On commencement date for Private Healthcare Facilities Bill, it is on the Gazette date of the head of the FEHD. So that is Part 1, Clause 1. And Clause 2 in Part 1 is interpretation. There are a few more important terms, and that is the relevant premises and also the authority and also the private healthcare facilities, medical procedures, and also the services organizations and medical services. Now, because the interpretation of these terms is relevant when these terms come up in the clauses themselves, so when we go to those clauses, we will further expound on the interpretation. Now, on medical procedures, the legal advisor in October 2017 had made an inquiry about this term. For this term, we believe it is wide-ranging in interpretation, and we should not define it and restrict it. And therefore, medical procedure is a registered dentist or a registered medical doctor, something that they can provide in reaching medical purposes and targets. And we have also come up with terms with the target and purpose of explaining different licenses in different suitable for different premises, what kind of medical procedures they can execute. So this is in terms of interpretation. Legal advisor? For medical procedure, the response from the administration is that even though it is not defined in the draft, but the administration believes that this should include improvement of health and diagnosis and also treatment of patients. Now, if we refer back to the anesthetic as the use of anesthetics as mentioned by the administration, I would question whether the administration of anesthetics is also a medical procedure. I would like to see clarification on that, please. In the definition, there are two parts to the licensing. For administration of anesthetics, it is not a medical procedure, but it is possibly a medical service. So there are two parts to this. It is not a medical procedure for the administration of anesthetics. But for eyebrow tattooing, for instance, we have discussed this before, even though this is something that a medical doctor may take up as a procedure, but in the discussion, this is exempted. That is, tattooing on the body for eyebrows, etc., would be exempted and not be included in here. Chair, concerning the legal advisor's point, now in the premise where there is an administration or putting on an anesthetic cream, let's say, an anesthetics cream is put on the patient, would this, in the premise, would this fall into the ambit of this bill, please, then? Any supplement, please? Now, for medical procedure, the putting on of an anesthetic cream is not a medical procedure, not as defined in this bill. But as I've mentioned just now, if it is diagnosis, treatment, or improvement of health for these purposes, then this would be a medical service. Now, I'm very specific, Chair. Maybe I can explain it as follows. Now, if there is a dentist or a doctor in a certain premise provide medical service, then this place will become a premise under the definition of this bill.
So if it's not the doctor applying the local anesthetic cream, then it is not a medical procedure, and therefore it will not be caught by this bill, but perhaps by another piece of legislation. All right, so you're asking the client to apply the cream by herself if she wants to do a tattoo of her eyebrows, and that is okay, right? If the beautician does it for her, then because she's not supposed to use local anesthetic cream, then she will be in trouble. Not necessarily. Now, is this an exempted procedure? Can Mr. Fong please explain more clearly? Let me try. Different ordinances regulate different procedures. Now, for the cream itself, if it is the cream belongs to the client herself, and she asks somebody to apply for her, that is okay, for sure. She will not be caught by this bill. But the cream has to be supplied by the client, and yes, and applied on the client. This is the regulation cap 161 and 138. Whether it is a medical procedure depends on whether it is done by a doctor and not anybody else. Is that correct? Under Clause 2 of the bill, now I was talking about two things. First, the legal advisor asked about a medical procedure, a procedure. Under this bill, the procedure might not be done by a doctor, but if it is invasive in nature, there's the chance that a license is needed. But I'm referring to another concept. Under Clause 2, we have medical services. And there is a definition for medical service. And here, as said by Mr. Fong, it has to be done by a doctor or nurse. A dentist. If the applying of the local anesthetic cream is by a doctor or a dentist, then it is a medical service. If not, then it will depend on whether the cream is purchased from a medical registered medical practitioner or from a pharmacist. And the person has to strictly follow the direction of the doctor, and that will be not be caught by Cap 161. What about removing of a wart or using the application of a laser and the application of hive? And the person who does it is not a doctor, but the beautician might have undertaken a course in Hong Kong overseas and got a certificate. I'd like to know whether the premise is a medical premise and will it be regulated by this bill. A simple answer is not, but it all depends on the circumstances of the case. Now, the bill doesn't define it as a medical procedure under this bill. Well, because for that product, it's not defined whether it should be done by a doctor or not. But if it is decided that in the future it can only be done by a doctor, then that procedure will be regulated by this bill. Is that right? Yes. And I think that is the greatest worry of the industry, and their concerns have not been fully addressed yet. Now, if it is to be done by a doctor, then it will be regulated by this bill. Dr. Chen, let me help you. Now, you have to let Mr. Xu understand. This bill is about what a doctor or dentist does at the premise, and he will be regulated. This bill seeks to regulate doctors and dentists only. You talked about LA cream. No. And this is about an act which may or may not be relevant to this bill. This bill regulates what a doctor or dentist does at the premise. Their conduct or their acts will be regulated. Now, through you, Chairman, I'd like to answer Mr. Xiu's question. Now, in fact, this will only regulate doctors and dentists. I think you can prepare a video and teach the industry to abuse the loophole. I am of the view that there are gray areas in this bill and there are loopholes. All right, someone brings along the local anesthetic cream or the hive and the machine for the procedure, and then he will not be regulated. Now, you can ask me to help you to explain. And this is exactly my question. If it is done by a doctor or dentist, it is regulated. If it is done by somebody else, then it is not regulated. This is exactly where the problem lies. Doctors and dentists accept this bill. We accept regulation by this bill. We are very disciplined. But if we are talking about same act, and somebody says that it's not done by a doctor or a dentist and is directed by somebody else, then that is the problem. No. Under Cap 161, we regulate illegal medical practices. So if the act, there are two tests. First, the act is for treatment, disease treatment, and second, it will cause harm to the person. If these two are satisfied, then the person can be convicted. But for illegal medical practice, even without these two conditions, a person can be convicted. So, of course, I understand this. But I have seen too many complaints on a weekly or monthly basis about someone who is not a doctor or a dentist carrying out procedures suspected to be medical. And in fact, I and another member are handling a case that is about to be reported to the police, and you have to check whether there is any harm. Well, it is very difficult to get the evidence. We have many cases that cannot be handled or not accepted by the police. Of course, I understand there is Cap 161. Now, if it is a doctor, he can be called and his license can be invoked. That is easy. But we're talking about someone who is not a dentist or a doctor carrying out some procedure and cannot be regulated. And a supplement, I thank you for your concern. But I must reiterate that the bill regulates the premises. Is a premise-based regulation. We are not regulating legal medical practice. It is being dealt with by another piece of legislation, not here. Dr. Pierre Chen said that somebody was teaching the industry to abuse the gray areas. I'm afraid I don't feel the same. Legal advisor. Regarding invasive procedures, you would like to exempt such procedures under the bill, and in what form, in what way are you going to grant that exemption? Dr. Chiu. The speaker is off mic. We carried out a public consultation prior to publication of the bill, and how to differentiate between medical and beauty procedures. Tattooing is invasive in the sense that the skin will be pierced, but that's the consensus between the medical and the beauty industries. These are traditional. This is a traditional industry, and people are aware of the risks. And then there was the consensus that tattooing will be exempted. If there is suspected illegal medical practice involving tattooing in the main, well, the current legislative position is clear. Now, the legal advisor is asking whether you will implement that by means of a document or what? Why do I have this question? Because under the bill, there is the term medical procedure. And if premises have to be licensed if medical procedures are being carried out. Now, you mentioned that tattooing involves piercing of the skin and also involves risks. And some of them will have to be done by a medical doctor. Will they be caught by your definition? And we do not see the exemption of tattooing in the bill, and therefore I have this question. Mr. Lee, thank you, legal advisor, for your question. As said by Dr. Chiu, whether tattooing of and also tattooing of the eyebrow is a medical procedure. We've tried to understand that with the medical industry. And it's confirmed that the public are well aware of the risks associated with these practices, and for most cases, they're not done by a medical practitioner. So we have publicized to the cosmetic as well industry and medical sector that this is not a medical procedure. And as said by the legal advisor, we do not have a definition for medical procedure in our bill because it is very wide and it is inappropriate to fix a rigid definition for it. So there is no such definition here, and therefore no exemption is needed. The government's decision on tattooing has been widely publicized. The public, the medical sector, and the beauty sector understands that this is not a medical procedure. Any other points? If not, can we continue? Mr. Lee, yes? Clauses 3 to 9 of the bill will give a definition of different types of medical services, and also the scope of PFHs that should be regulated. Now, 3 provides a definition and premises that are used for emergency treatment will not be covered, and the PLAs, Hong Kong UCUH, and have got PFHs, and they have PFHs, and they are mainly for research and education purpose and are not for providing services. So an amendment will be provided under Part 1. Clauses 1 and 2, there will be CSAs to ensure that PHFs that satisfy these procedures will not be regulated. They have to be facilities operated and managed by the 2 universities, and there are clinics and health service establishment, hospital, day procedure center, and if they are mainly for medical or dental research and education, they will be exempted. So we intend to amend 2 and 3 of Part 1 to exclude PHFS run by the 2 universities, Hong Kong U and CU. All right, questions? Dr. Kwokaki. Well, we have we've been arguing over this for a long time. I think this amendment will open a big loophole.
This is to regulate all organizations providing medical service to the people of Hong Kong. But on the other hand, some institutions are privileged. For example, the 2 universities. Why are they not to be regulated? This is to protect all patients, isn't it, this bill? And you are insisting on exempting the 2 universities. You are forcing the people of Hong Kong to accept a bill which has a big hole in it. This hole is very big. You may say today that it is a very small hole, what the bill does not cover. But the universities are being commercialized. And for instance, the medical doctors serving in the teaching hospitals are allowed to practice commercially. And still, you're allowing this big blank in the bill, exempting them. Members have spoken before me saying that this is unnecessary. Now, why does the government still go ahead regardless? What is the reason for the exemption? You want to provide this privilege to the 2 universities. Why do you want to do that? Well, Dr. Kwok, in fact, this has been discussed at length earlier before you entered the room. I will allow you time, but it's been discussed at length and in various rounds. Perhaps the administration can provide a supplement? Thank you, Chair, and I understand the concern of members. We have raised a point earlier today saying that where the practice is not for teaching and research, then the exemption would not extend to them. It is very clear that if they do not comply with the 3 requirements listed here, then this exemption will no longer be valid for the universities. Mr. Chair, if they say and claim that what they do is for research and teaching, it will not be difficult for them to do so. What does the universities do which is not for research and teaching? Well, I've worked in the university hospitals as well. Give me one clear example where the university is doing something specifically not for research and teaching. I mean, as long as they label it as research related and as long as data is being collected, then they can claim that it is for research purpose. It's easy for them to make that claim. Chair, we are not exempting all clinics under the 2 universities. Some clinics are not exempted. For example, their staff and their staff clinic is not exempted. But in Appendix C of the paper today, there is an agreement, a patient's agreement, saying that at the point of treatment, the patient would be asked, your case will be used for teaching and research purpose, and the patient will sign and agree to that. So it is not all clinics. This kind of procedure would be exempted. Not all clinics under the universities will be exempted. I would like to know from the health department that this is their understanding as well. What is this agreement, this patient agreement? How is it going to be monitored? Is it posted outside of the door of the clinic? No. If they're not within our, they're not within our terms of reference, we will not be monitoring or going for site inspection at these clinics. We will handle the cases should there be any complaints. The department had made it clear that they will not be enforcing this law. Who enforces this law, please? Who enforces? Well, it depends on whether there are complaints. Now, the universities, because they already have a very complete and robust mechanism for their own monitoring, and also we have ongoing communication with the 2 universities, and they have very good corporate governance. Under the situation, we think that they'll be able to handle this.
But I must stress that if under whatever circumstances we come to aware that the facility is no longer for research or education purpose, the Department of Health can ask it to be licensed. If there is any new facility that is proved to be for this purpose, not for this purpose, we can require to get a license.
Now, who's going to enforce the law? If it's not you, if it's not the her department, who's going to enforce the law? Well, enforcement comes in many forms, and we will have to look at the level of risk. And for the private clinics, healthcare facilities, it depends on the risk, how high it is, how low it is, before we will come up with the right form of enforcement. Chair, we're talking about legislation here. We have to abide by certain principles. It has to be fair. We have to be true to the legislative intent. And this bill is about clinics, day medical centers, private healthcare facilities. And under this definition, the two universities' clinics should fall into this definition. The relevant medical procedures, shouldn't they also be regulated with the same standards as the other facilities, whether they are for charity, for research, for scientific studies, for teaching? Because this is clear in the bill, and that is the law is that for healthcare facilities, that there should be a good governance, that there should be a complaints mechanism and also transparency, and that the government can enforce this bill. And the Mr. Fong is saying they are exempted because they are conducting research and teaching. But my question is, how does this conflict with the purpose of the bill? I mean, if they conduct research and teaching, if complying with the bill, with the law, is detrimental to their practice in research and teaching, then that's another matter. If it makes it difficult for them to attain their research and teaching targets, then that's one thing. But if this is not the case, then I really do not see the logic why the two universities are not going to be regulated as well. But if the administration says that two universities already comply with the regulations, they already do that, then, as I have mentioned earlier, they have to do nothing more in order to comply with the law. And therefore, we should not make them exempt from the law. I mean, there's one principle which is very important in law, and that is everybody is to be treated fairly and the same in front of the law. I mean, how are they different, these universities? All HA clinics are not included under this law. And the administration had said many times that the two universities' clinics follow and comply with the HA practice. But it's also said that there will be further information provided to us concerning this, and there will be a CSA procedure, which means that we will have further opportunities to discuss this. Mr. Fong, will you make a response to the point just now? And then we will be discussing exemptions in the next meeting when we have further information. Perhaps at CSA, the government, perhaps you can raise this, or we can raise this as a matter to follow up. Chair, this bill, the title is Private Healthcare Facilities. Now, if HA clinics are private healthcare facilities, then they should also be included under this bill. So, HA clinics, are they private or public facilities, please? Can you respond to that, Mr. Fong? And then we have other members who would want to raise questions. Yes, Chair. Concerning CAP 343, they exempt the two universities' clinics. This is already the practice now. This is not a new practice. And also the medical schools of the two universities also do not come under this law. So these 14 healthcare organizations under the universities, we believe, should also follow this practice, and that is they should be exempted from the law, this particular law, and we take into account a number of factors. First of all, it's not new, and they already comply with the HA procedure, and they also for teaching and research purpose. I hope you understand, members. Well, Ho Kwon Yu, Chair, I just want to find out a bit more. For exemption, I am fine with it. I have no objections, but we need to know what we're exactly talking about. The two universities, their clinical treatment and their experiments, they are done under the HA hospitals, such as the Prince of Wales and Queen Mary Hospital. And I know that there is another regulation that's under HA, and this is about private healthcare facilities. It's good that I know that there is, and I'm satisfied to know that there is a public healthcare facilities regime to regulate them. My question is, for the two universities, how many facilities of scale are there conducting research and teaching, and how big are they? Because according to what I know, they are done in the hospitals, which is under the HA regulation, and I'm totally fine with that because the HA will be regulating these hospitals. But aside from these, how many facilities are under the two universities, and what kind of scale is it? Are we talking about? How many patients are treated, for example, each year for research and teaching purpose? To answer your question, altogether there are 14 such clinics under the university. Some are actually not clinics, but clinical trial center for testing of drugs. And this is clear. This is for scientific research, for drug research. There are such instances as well. Now, what about the professors who treat outpatients? And it's for commercial gains. I mean, is this under HA or where does it fall into? That depends on the case. It may be done within the HA-regulated university hospitals, or it can be carried out in these centers, such as drugs testing centers. But these are not of commercial nature, true? Well, in providing the service, they charge a fee, as far as I know, in certain instances, from the patients. And what is the scale? Is it commercial? Is it cost recuperation? Cost recuperation only. Fine. Now, can you please tell members that the charge is not abusive and it is not on market terms. It is just for cost recuperation and it is for research and teaching purpose. Then I'm totally satisfied with that. And it is not of a big scale. Please provide that information to members. I mean, some members seem to think that if the universities comply with the requirements, then might as well since they comply, might as well ask them to be licensed. And what is just cumbersome is a biannual procedure for relicensing. But please provide the information.
Dr. Pierre Chen, just for members' information, in actual operation now for centers for research, they will not see private patients, will not charge patients, and they will not charge patients and ask them to try new medicine. And for teaching and research, we might invite a patient for primarily teaching and research purpose. That will not be considered a private case. That's our operation. But we have a gray area here. We do have private patients in these universities. Will they be regulated by this bill? Now, this is just for members' information. If the facility is really primarily for teaching and research purpose, there will be no private patients, and no private patients will be willing to pay for a service that is for teaching and research purpose. Thank you. Mr. Fong, we have to supplement. We say that there is a consent form for patients to sign. There is the opportunity that it is a private patient. For instance, it is referred to the university by the HA. Now, these patients have to pay. Still, these cases, these patients may choose whether to opt in or out of the research and education purpose of the two universities. On the question of exemption, when we have further information from the administration or when the administration proposes CSA, we will have another round of discussion on that. May I ask the legal advisor, so far do we have any questions for the bill? If not, Mr. Lee, please go on. Clause 4 of the bill provides meaning of hospital. Now, for a hospital, it provides lodging, and for it's not to be used for carrying out medical procedures on patients with lodging or receiving pregnant women or childbirth or women immediately after she gives birth to a child. And meaning of a day procedure center, day procedure center will provide scheduled medical procedures with no lodging, and Schedule 2 are there in column 2 but not column 3 of the schedule, and such medical services are provided without any lodging, and that is a day procedure center. And for minor medical procedures, they are not scheduled medical procedures, and no lodging is provided. Clause 6 provides a meaning of a clinic. A clinic, compared to hospital, cannot perform scheduled medical procedures to patients and will not provide lodging. Clause 7, meaning of health services establishment. The assistant legal advisor wrote to us in last November raising inquiries on this. A health services establishment 7C tried to be as wide as possible, trying to cope with evolving changes in medical technology. And under Clause 101 of the bill, the Director of the Secretary for Food and Health can specify different classes of health services establishment. In this schedule, there is only one. That is those for education, scientific and research purpose, and they also provide lodging for patients for clinical trials, and these are the only type of healthcare establishment set out in Schedule 8. Clause 8. The word premises. Yes, please hold on, Dr. Chen. Now, on Clause 7, I'd like to ask whether the ALA has anything to add. No? Then Clause 8. the term premises appears in many clauses of the bill, and therefore for the licensing of PHFS, we have to provide a definition for premises. Although it is already defined in Clause 2, we would like to define further in Clause 8. For instance, we've already explained to Dr. Chen what is meant by in close proximity and how premises are regarded as forming a distinct whole for the facility to function as a single entity. All right, I have to follow up on my previous question now. Now, physically connected by internal access among themselves, that is easy to understand, but I thank the administration for the reply. Clause 8, A and B have to be considered together, and I will relay the administration's response to doctors concerned. All right, I asked, how do you understand what is meant by physically attached or in close proximity? For instance, floor 16 and floor 17. And what about a unit across the street? And what about the 5th and the 23rd floor? How do you understand physically attached or in close proximity? And if they apply for exemption, should it be made to the Director of Health? And what if plans are submitted, and if can they sign a declaration form to say the two are not connected? And is there any appeal mechanism against the decision of the secretary? Now, if they want to be exempted, like the two universities, they want to enjoy the same privilege, can that be allowed? Clause 8 is meant to provide flexibility. If we have premises that would want one license to cover two, say, adjoining units, they want the two units to be licensed under one license. So we're saying that so long as they are operated as a distinct whole, then they can be regarded as a single entity, and then there is the feasibility to apply for only one license. Now, if the two rooms are connected but they are doing two different things, they are not operating as a distinct whole, then two licenses can be considered. So Clause 8 is a flexible option for the applicant. There is no preventing the application of two licenses. So this is to a later concern of Dr. Chen. And if somebody is dissatisfied with a licensing decision, so there is an appeal mechanism under the bill. When we will discuss it when we come to that clause. Dr. Chen has a question. What about the 5th and the 23rd floors? Two units on these two floors. How should that be understood? Mr. Lee's explanation is that the clause is for applicants that do not want to apply for two licenses. If they can prove that the two units operate as a whole, as a single entity, then they can just apply for one license. But if the units on the 5th and the 23rd floors are different, then of course they have to apply for two licenses. Now I understand. The intention is to offer flexibility. You can apply for one instead of two licenses to save cost. All right. I have given you, we have asked us so many questions. Now, we ask questions about the two universities. We all have exemption in mind. Now, we support your regulation, but please do not regulate me. Now, I understand. We are talk about exemption for individuals, and there may be some joint practices with 6 or 8 doctors operating on the same floor, and they will all be regulated. Now, if there are 4 here and another 4 there, they are self-employed, and they can consider applying for exemption. So we talk about a physical proximity or what? How can they fulfill your requirements? They are not. They're not like the 2 universities, which can discuss with you privately. All right. They would like to know how can they be eligible for exemption. Yes, it's fine with me if they can be covered by 1 license, and my concern is how they can get exemption. Well, if need be, we can meet with individual doctors to allay their concerns if they are unclear about the bill. Dr. Chiu, as explained, the intention of Clause 8 is to let the industry know how many units can be covered by 1 license. Now, if the 2 are really 2 different units, then they can tell us and they can seek an exemption. But now there can be 5 doctors operating in 1 unit and they can be covered by 1 license. But there may be 5 different doctors operating in 1 unit, and now different units in a building, they can ask for an exemption from us so long as they can satisfy Clause 41, small medical practices and other conditions. Thank you. All right, 41. The number of doctors and whether they are employed or not. I thank you for the information provided in the last meeting. But this is about the definition of premises. All right, they can fulfill your requirements both software and hardware-wise, and then they have filled out all the forms, and the government is satisfied, and then an exemption certificate can be granted. That's the main purpose of my question. They like to know how to proceed. They have they are ready to split their operations. For instance, they will do away with the corridors. They are ready to do that in order to fulfill your requirements.
If they're in different units, then they can apply for exemption. That's a general principle. For the private hospitals, very often we see, apart from providing hospital services, they would have some day clinic in nearby addresses. Does it mean that under this bill they will have to apply for 2 licenses? Correct. Cap 165 is for licensing. 1 hospital license will cover the nearby day clinic as well, or medical clinic as well. But for the future, we will be handling this as follows. If the hospital provides clinic or day clinic services nearby, or then that can be covered in 1 by 1 license. But if there are satellite clinics established by these hospitals, then they will require a separate license. And Chair, we go on concerning outreach medical services, and that is a part of the healthcare services provided in a temporary setting by the government or the HA. This is about outreach medical services. We go on to the draft, Part 2, Clause 10 to Clause 12. Clause 10 deals with the prohibition on operating facility without license, because the risks involved are relatively high and therefore the penalty is high. the fine of 5 million and imprisonment for 5 years is a maximum penalty. And if the facility is not a hospital, then that would be imprisonment for 3 years. And Clause 11 is a display of license in facility. A copy of the license will have to be posted so that consumers and patients will know whether this is a licensed private healthcare facility, as well the type of the facility, the practice of this facility will all have to make clear. As for Clause 12, it says that there will be prohibition on performing treatment or procedure causing personal injury. If a person who is not a healthcare professional must not on any premise other than an accepted premise perform a medical treatment or medical procedure for another person who may be suffering from a disease or injury or disability of mind or body. And so our understanding is that the procedure must be carried out by a healthcare professional. And there had been certain queries. In our response, we have said that this is a very serious confection, and we refer to Cap 343 for this violation, and it will not be overly lenient, and also it would not jeopardize other conviction clauses under other laws. Now, because we have exempted Hong Kong U and CUHK clinics, and therefore in accepted premises, we would also include the premises controlled and operated by the two universities. Legal advisor. Thank you, Chair. Thank you for the response from the administration concerning the conviction. I would like to ask that it says here that the persons will have to be suffering from a disease, etc. Now, according to this drafting, then what about beauty clinics? That this will not be included, right? Beauty clinics would not be included, right? So the people who go for treatment in these clinics are people who want to undergo beauty treatment, cosmetics treatment, etc. Your understanding is correct. Our focus is indeed for people suffering from disease, injury, or disability of mind or body, and if a medical treatment procedure is to provide it to them, and only then would Clause 12 would this bill be applicable according to Clause 12. What about first aid out of injury? What about first aid procedures? Would this be included? In the definition for private healthcare facilities, first aid emergency procedures is not within the definition here. That's not included. 12H, it is already made clear. 12H, treatment given by way of first aid. It's already been spelled out. Part 3 is there will be 7 divisions. The first division is Clause 13 to 19, and for Clause 13 it is about the application for license, the information to be provided at the application, and Clause 14, the applicant, 15 to 17, director's decision on the medical procedure, and 18, grounds for refusing to issue the license, and then 19, validity period of the license. Members, any questions? Legal advisor, anything? Mr. Lee, yes, bring us through in detail, would you, please? Yes, we're talking about Clause 13 here. It is about the information to be provided at the point of application for license, what type of facilities, which type under the 4 types, and what kind of services would be provided, the scale, and the practice. What practice is it? These will have to be provided at application. The 4 types of facilities will each have their own required practice and information to provide. Now, about the daycare centers or the homes, what about those? For homes, in the interim, we have come up with certain stipulations. Most of these may be transferred to Cap 459 old age homes regulation under the Social Welfare Department's ambit. Otherwise, they will be licensed according to this bill. At present, there are 2 to 3 registered care homes which also provide palliative service. And according to Cap 459, they can continue to register as old age homes. If they register under this law, they become hospital, or they will, or if they do not comply with all the requirements, then they will have to make the changes in order to apply for hospital status. Yes, they will have to apply. There will be interim stipulations. If they want to transfer to Cap 459 facilities, they can do so. That will be under Social Services Department. If they want to stay in this law, then there is a chapter later on that we will go through later on about this interim arrangement. Thank you. In that case, please continue. Clause 14, the applicant, his qualifications. If it's a hospital, then the applicant must be a legal entity with a board of directors. If it's not a hospital, but other forms of clinics, then the applicant can be a person, a partnership, or a legal entity, or a yes, those are the main situations. We go on. Or it can also be a society. We go on. Clause 15, director's decision on the medical procedure, and Clause 15 spells out the decision of the director on whether the procedure is a scheduled procedure, and Clause 16 is that the director may inspect premises and require amendment to the application. Clause 17 is that the director can issue or refuse to issue license. It spells out here that it is only under the grounds spelled out in Section 18 can there be a refusal to issue a license. Clause 18 is grounds for refusing to issue license. The director can only follow these grounds for refusing to issue a license. Clause 19, validity period of the license according to risk considerations. The longest period is no longer than 2 years for hospital, for day procedure center, no more than 3 years. Clinic, no more than 5 years. Scheduled clinic, no more than 1 year. And a license for health services establishment is valid for a period specified in the license, which is to begin on the date specified in the license for that purpose. Now, concerning for the validity period, where do I see the fee table, please? Is there one? For application fee table, it is in Appendix 3. For application, amendment, and relicensing, we will spell out the fees. Now, for scheduled clinic, no more than 1 year. Is that too short a period, please? Dr. Chiu will answer that question. There is a history to that. According to CAP 343, there was a batch of clinics which were not, or doctors which were not registered under the relevant authorities to provide lower level and lower charged medical services to the community. And so these are limited registered medical doctors. And we will look at the relevant risk level. These doctors now go for annual licensing. And therefore, for these clinics, scheduled clinics, we will follow that 1 year period. As for the fee, we will also differentiate this from the other situations. For example, the clinic where the validity period is not more than 5 years. So we want the fee to be reasonable as well. Right. If the fee is overly high, given that the validity period is but 1 year, then we should be cognizant of that. Just a point concerning the 5 years. It's for $945 and it's $120 for relicensing for scheduled clinics. That's the fee. Thank you. Division 2, Clause 20 to Clause 22. Clause 20 is about the application for renewal of license, 21 renewal or refusing to renew license, and 22 before determination of renewal application. Anything, legal advisor? Any questions? That's Clause 20 to 22, Division 2. Members, anything? None. Now, because we have 1 more minute to go, we will have to close the meeting here. This meeting has come to a close. Anything to add from the Secretariat? Our next meeting is 8:30 to 10:30, 16th of March. It is a Friday. But we may be clashing with the co-location bill, which starts 10:45. So I think we should be able to conclude our discussion by then. All right, this closes our meeting here. Thank you for coming to the meeting.